Thank you.
In the matter of claim on the application of Suffolk Energy Actions as SPV Limited and Secretary of State for Energy Security and Net Zero Hattad.
Thank you. Yes, Mr. Philcott.
Well, I'm on my feet before Mr. Westman-Smith continues, simply to explain an additional extract which we put in front of you. This is in response to submissions made yesterday. I
Yes.
provided a copy to SPV and explained the point.
Yeah.
This is something which is otherwise missing from tab 1 of the authority part, section 103 of the Act, which identifies the functions of the Secretary of State.
Right.
So it would probably naturally sit after page 62 in the bundle in tab 1, because that we have a section 102B that then goes through to section 114. So
All right, let's put it in.
it's essentially the counterpart to section 74, which identifies the functions of the examining authority, which your lordship have at page 21.
Yeah, well, we'll put it in slightly out of sequence, but it has to be after page 63. Thank you very much for that. Yes, Mr. Westman-Smith.
May I just point out that that document on the reverse side also includes section 104, which I referred to in my submissions yesterday, so your lordships have that.
Thank you.
Yesterday I was in the middle of dealing with the facts, and I was about to go to the Secretary of State's decision letter.
Yes.
The decision-making process before the Secretary of State is explained in the witness statement of Mr. Dawkins, tab 26 of the supplementary bundle, and dealt with by the judge in some detail, paragraph 123 and following. I'm going to focus for the purposes of my oral submissions on the decision letter itself. And if I could ask you to turn that up, it's in the core bundle, it's tab 30, and the relevant paragraphs are on page 523.
Yes.
And the court's already been to these paragraphs and is familiar with them under the heading Use of Non-Disclosure Agreements, the identification of the issue raised by the objectors, and the particular drawing attention to the submissions made to the Secretary of State after the examining authority reported. But it's paragraph 26.3.1 that the Secretary of State summarises position and says, in brief, concerns were raised that parties entering into agreements for voluntary acquisition of land or rights in it were required to sign non-disclosure agreements that prevented these parties from participating, and consequently the EXA not getting a clear picture of the strength of objection. So it's identifying the two main concerns, the impact on participation and the consequence for the EXA of whether or not they were getting a full picture, i.e. did they have enough information. And the Secretary of State goes on to make his, draw his conclusions at paragraph 26.32. And again, we looked at this yesterday, but it is important, as my Lord Justice Lindblom pointed out yesterday, that the conclusion is, having also reviewed the totality of the EXA's report, the Secretary of State considers that all relevant issues were raised. What does that mean? It means that parties brought issues to the attention of the EXA, for example, through objections and through objections by landowners. Then those issues were explored by the examination. That's the examining authority's role, section 74. And in light of that, the Secretary of State concludes that he has the necessary information to enable him to make the decision. So issues raised, including 3 objections, explored, question asked, do I have enough information? Asked and answered, yes, I do. My learned friend says that's missing the critical issue of whether information was suppressed or distorted, and he says that in his skeleton argument, paragraph 75, Roman 1. But I say that's not ultimately a fair reading of the decision, because the Secretary of State addresses both the issue of fairness, and you can see that conclusion. He adopts the EXA's conclusion on fairness in relation to landowners. At the foot of this page, at paragraph 26.34, he concludes a fair public hearing, no breach of Article 6. And so both fairness and whether or not there was sufficient evidence. And that was the right question in the context of the nature of this decision, the administrative decision to be taken in the public interest. I started my submissions with. So it's not the right question is not, is there any more information out there? The right question is, do I, the decision maker, have enough information to take the decision in the public interest? And that's recognising the points raised yesterday that, in practice, there will always be a bit more information out there. But that likelihood can't be allowed to grind decision-making to a halt where the decision-maker takes the view that he or she has enough information. So overall, the Secretary of State engaged with the heart of the complaint, which was fairness, and I'll come to show you that next, and the practical effect of the complaint, which was the suppression of evidence. And that resolves itself in the question of, do I have enough evidence? And he asked that question and he answered that question.
Does the Secretary of State have a view about whether these clauses are something to be encouraged?
I don't have direct instructions on that, but I'm going to come to the Fulham case, and the Secretary of State's position is that the court in that case set out the appropriate principles, and that includes there's no public policy issue with such agreements. So if I may, I'll park that until I get there.
Of course.
And I'm going to finish on those contractual points, because that's where my learned friend started as the main plank of his case. And so I'm going to finish there addressing your lordships on that. So my next heading is, what was the complaint?
Is this one of your main headings then?
It's a subsidiary heading of the facts.
Right. So what was the complaint?
What was the complaint?
Right.
So it's still under 3, the facts. And it's important to identify what the complaint was, because that contextualises the decision taken by the Secretary of State. And as the judge identified, it's in the judgment at paragraph 26 and 138. You don't need to go there, but 26 and 138. There was no allegation of procedural unfairness. So this claim has never been about an allegation of procedural unfairness. That hasn't been a pleaded ground. But at one point yesterday, my learned friend did seem to say it was about fairness, but no fairness ground has been pleaded. But it's important to note that was the case put by Seas in front of the examining authority. And one can see that by looking at Seas' submissions during the examination. If I could take up the supplementary bundle.
Are we putting the decision letter away now?
We can do that, thank you. And tab 11 is the March complaint. It's the most substantive complaint made during the examination. It begins on page 162 of the bundle. You see it sees written submissions, deadline 25th of March. And at 164 you were taken to the executive summary yesterday and the complaint. But could I ask your lordships to turn to page 177 of the bundle?
177.
177, and this is section E, the willingness of landowners to come forward, the irreparable damage done to the planning process. And this section follows an analysis of the agreements. And at the foot of page 177, paragraph 44, it concludes, the damage has therefore been done. SPR has succeeded in undermining the planning process. And next paragraph, it is now impossible for the damage to be remedied. And then turning forward in the document to page 192 of the bundle, this is coming to the conclusions of this document. At paragraph 122, C sets out the way forward. And the first point is to be noted. First, Roman 1, there is now a substantial body of evidence before the EXA, which leads to the conclusion that the application should be rejected. So that's their conclusion. But the observation is there is a substantial body of evidence sufficient on which to make a determination. Secondly, Roman 2, they invite, second line, the EXA to make the above finding, i.e. on the balance, the planning merits, it should be rejected, but also to find that the use of gagging and non-opposition clauses has meant the procedure has become unfair. So it was a fairness point. And then third, again, it gives rise to procedural unfairness in relation to the evidence collection process. This amounts to an independent reason to refuse consent. So the claim was that you should refuse on the merits, and there was substantial evidence on which to do that. But there's a freestanding point about fairness as well. And then this can be seen again in behind tab 14, which is submissions made on the 15th of April is the date. It's not in the document, but you can see the date in the chronology, which is agreed between the parties. I said chronology, I meant index to the bundle.
Yeah, so the date of this was?
The 15th of April, 2021.
15th of April, 21.
And at paragraph 10 at the foot of page 264, as fully set out in C's earlier submissions under the law, and then it's about fairness. And then 4, if the procedure is unfair, it will be set aside. 5, once the procedure has been established as unfair, there's no possibility for that to be remedied. 264.
So can you just give that reference again, the
Of
page
course,
reference?
it's the supplementary bundle, page 264,
Thank you.
paragraph 10, Roman 4 and 5.
Well, it's also paragraph 11.
Indeed. And then paragraph 25 as well on 266, the conclusion is unlawfully unfair procedure. And that position was maintained before the Secretary of State in the subsequent submissions made by Seas directly to the Secretary of State. I'm not going to take the time to go through all of those because the judge has done that in some detail. And he does that at paragraph 116 on, so page 154 of the core bundle.
Do you want us to look at those?
Can I just ask you, yes, please, could you turn up page 154? So these are the paragraphs where the judge deals with C's complaint to the Secretary of State. And your lordships have read that, but could I just highlight please paragraph 120 in particular, where having reviewed those documents, the judge says C's firmly, second line, nailed their colours to the mast of procedural unfairness, continued to maintain unfairness could not now be cured. The alleged failure of the panel to address the complaint could not be remedied. There was no scope in law for the Secretary of State to seek to plug the gaps and the evidence, and any decision would be quashed. So that was the way the complaint was put. And so the position that was articulated to the panel was there's irreparable damage. You can't do anything about it. The position put to the Secretary of State was it would be unlawful for you to seek to plug the gaps. No way through being identified. Rather, it was to place difficulties before the decision maker in support of the refusal, at least of the onshore elements. And at no stage before yesterday was any steps identified by Seas that it was suggested that the EXA could have taken. Now, what was said yesterday was that the EXA might have ruled on the legality of the agreement. But to that, the response is, first, there were no option agreements in play, and we'll look at that. They were non-signed during the examination, as a matter of fact. Secondly, as we looked yesterday, section 74 of the Planning Act 2008, page 21 of the authorities bundle.
Sorry, which section?
Section 74.
Yeah.
And the powers of the examining authority are to examine, report, recommend.
Yeah.
They also have powers to make procedural decisions. That's section 89 of the Planning Act 2008, page 33 of the bundle. But the power to determine issues lies with the Secretary of State, section 103 that was handed up earlier this morning. So not only were there no agreements in existence at that time, no option agreements in existence at that time, it wasn't within the purview of the examining authority to determine their legality. What they could have done is ask for further information. And they did that. And I took your lordships yesterday to the examining authority report that shows that they asked for further information, not once, but 6 times during the examination. And that's core bundle, tab 33, page 583, and it's paragraph 1.4.51, 51.
Are you taking us there now?
No, it's just a reference.
Right.
You'll recall yesterday they requested
We
further
did look at it
information on
yesterday.
6 occasions.
And was the further request for further information related to the clauses?
Not directly. It was related to them satisfying themselves they had sufficient information to determine the application on the merits. That takes me to my fourth heading that I gave you yesterday, which was, does the evidence show that there was a practical impact? That is a key part of my learned friend's case, that namely the land negotiations led to a chilling effect, which distorted the level of evidence. But the appellant has shown and provided no evidence of any practical impact on the evidence collection process. In particular, there's no evidence that either the heads of terms or the option agreements led to landowners preventing or limiting access to their land, nor of the examining authority or others being prevented from accessing the affected land or obtaining information about it. And the reality is the appellant has had every opportunity to do that. The time frame is relevant. We're looking at documents that are dated 2021, and we're now in 2024. And more importantly, the appellants were given a specific opportunity when the interested parties made a request for further information under Part 18 of the CPR. And that's in the supplementary bundle at tab 28. So beginning on page 494. So tab 28 is the request. I don't need to take you to the detail of that because the request is summarised in the response, which is in tab 29. And focusing on the key requests are really request 2 and 3. And 2 is on 501 of the supplementary bundle. And at paragraph 9 of the request, which is in italics, it says, please explain specific further steps, if any, which the claimant says the defendant should have taken to ensure that he had access to full information. And then the legal basis if he was obliged to take those steps. And then the response below is at paragraphs 8 and 9. The case of the claimant is simply that the Secretary of State needed to undertake a legally sufficient investigation. That would have included lawfully considering what steps were needed and then taking the steps. The problem is that he failed to do so. So not identifying any steps there.
Just a second, if you would.
Might be
So this is page 501. Yes?
Yes, 501, looking at request 2. And the request is in italics immediately under request 2, and it's really paragraph 9.1 of that that's most relevant. And then the response to the request is at paragraphs, confusingly 8 and 9 again, but of the substantive response. And the short point is no steps identified. And then request 3 is at the foot of page 501 going over to 502. And in short, what the request is what information is said to have been missing? And the answer is we can't know. So no identification of missing information.
Well, a similar answer was given to us by Mr. Bewley yesterday, because he says the effect of the confidentiality clauses is that one can't dig out information from the landowners to tell us what they would have said if they weren't bound by the heads of information.
Entirely so, and it leads you back to the question of, is there sufficient information? That's for the decision maker. Ultimately, the suppression of evidence point leads you to the question that, do I have enough to make this decision in the public interest?
Is that subject to a Wednesbury test?
It is. So however you cut it, do I have an adequate ES Wednesbury test? What further steps might I need to take? Wednesbury test.
Is there authority that comes close to substantiating that proposition? Not, I think, in this particular context, but anything that is analogous.
In the context, my lord, yes, in the context of EIA Blewett on adequacy.
Well, Blewett, I think Blewett was specifically endorsed in Friends of the Earth, but I may be wrong about that.
It was.
And that's Supreme Court
Yes.
authority.
Yeah. And then in the context of investigations, Tameside duty, Tameside, Tartu, and I address those in my skeleton argument. And I say those authorities are applicable in the circumstances because we're dealing with an administrative decision.
Right.
There were 3 examples that were put forward as to evidence of the chilling effects. And the judge deals with those in some detail. He deals with them at paragraphs 171 to 183 of his judgment. And the 3 headings are Dr. Gimson, the River 100 issue, and the Lloyd Bore ecological report. I just want to touch on the first of those. I otherwise rely on the judgment, because my learned friend hasn't gone to the other, the River 100 issue or the Lloyd Bore ecological report, and the judgment deals with those fully. Dr. Gimson. Dr. Gimson is an example of someone who signed heads of terms early in the process. The example heads of terms we have in the supplementary bundle is his, in effect. It's his mother's, but it's his. And it's dated the 13th of January 2020. The examination began in October of that year, so roughly 9 months later. Sorry, I'm being corrected. It's Dr. Jimson. So I apologise for that. So he signed up early, but was able to make representations and engage with the examination process. And nowhere in his witness statement does he say that he was actually prevented from giving evidence. And more to the point, he is an example of where the heads of terms that he signed and the proposed option agreement quite clearly didn't prevent him from participation. Further, the interested party agreed to specifically accommodate Dr. Jimson's ability to continue to make representations, even were he to sign the options agreement. And you were shown much of the relevant documentation yesterday. But the points that I would make are these, that whilst the appellant says that the adjustment to the standard options agreement clause to allow Dr. Jimson to make further representations on water and aquifers, that shows the interested parties not being flexible because of the limited extent of the carve-out. Simply put, it's an obvious example of flexibility and an offer made in the context of the conversations between the interested party and Dr. Jimson's agent. And you were taken yesterday to tab 3 of the supplementary bundle. I can just go back there to page 69. And at the top of that page, it's in an email from Samuel Jennings, Dr. Jimson's agent, to Dr. Jimson. Submissions regarding water, contrary to my email below, the terms do prohibit you from making submissions, so you're currently in breach of the terms if signed. However, I have discussed today with the agent for the IP, who is considering how we deal with the water concerns, and I will chase him on this tomorrow morning. And then over the page at 70, you've got the additional carve out for Dr. Jimson relating to water. That's in the context of the conversation between agents about water. And then at 72, at the top of the page, Mr. Jennings is saying to Dr. Jimson, let me know what you think of this halfway house. If there are any other elements of your submissions that you wish to retain, then there may be some more wriggle room. Now, there's no evidence he asked for any more wriggle room, but as Mr. Philbrook pointed out yesterday, the interested party made very clear in submissions to the examining authority that it was open to further discussions. And you can see that on page 280 of the supplementary bundle, paragraph 22. I don't think we need to go there. You were taken there yesterday, but it's page 280, paragraph 22.
Can I just ask you this, because I can see all that, and that may be relevant to the determination of this appeal. But what is the point then of having this type of letter if the moment someone needs to object, it's waived? Why bother? Because it will put off others.
My lord, do you mind just asking me that again?
Yeah, I mean, you're making the perfectly probable point in answer to the appeal that when push came to shove, the interested party waived the clause. So I was asking, what is the public interest in having the clause in the first place?
Well, the public interest stems from the context in which these letters come forward. That is necessary land acquisition. It's far preferable for the acquiring authority, or in this case, the developer, to acquire by agreement. It's swifter. In context where you're outside of the DCO, it avoids an entirely separate CPO process. And the government guidance is, and I'll come to that briefly, is negotiate, seek to acquire by agreement, CPO as a last resort. And so in all those circumstances, it's perfectly proper to have an agreement that as one part of it says, well, we've resolved issues between ourselves, don't continue your objection. And in particular circumstances, fact specific, it may be appropriate to do a carve out, but the standing back from the particular issues, the point is to try and avoid compulsory acquisition and get things done by agreement.
Thank you.
So, having dealt with the three examples, the judge dealt with the three examples, Dr. Jimson, River 100, Lloyd Ball report, and having no other suggestion as to what is missing, one's left with vague and unsubstantiated complaints and a theoretical argument. So with that, may I turn to the agreements? Now, in the sort of overarching structure I gave you yesterday, I said I'd deal with the submissions as structured in the appellant skeleton argument. But having heard my learned friend's submissions and his focus on the agreements, and having taken you to the decision letter, I'm going to now focus on the agreements, and you have our written submissions for some of the detail around that. So the context for approaching the agreements, I've just really touched on, and I won't repeat it, but it's a government policy that one should negotiate. And can I just draw one point out from that government policy, and it might be worth just turning it up. It's at page 508 and 509 of the supplementary bundle.
Yes. The document we're looking at here.
So, yes, it's the Planning Act 2008 guidance related to procedures for the compulsory acquisition of land. September 2013.
September 13.
Yeah.
Yeah.
And it's paragraphs 25 and 26, and 25 I've covered the substance of. It's acquired by agreement where practicable. But 26 is quite important given the way the C's complaint was put. And what 26 says is, second sentence, making clear during pre-application consultation that compulsory acquisition will, if necessary, be sought in order to help to make the seriousness of the applicant's intentions clear from the outset, which might in turn encourage those whose land is affected to enter more readily into meaningful agreements. So, whereas at the heart of the C's complaint is the suggestion of coercion by using the threat of compulsory purchase powers, what the government guidance says is do point that out, because they are there and you use them in default, and it may encourage people to enter into agreements. So there's nothing wrong with pointing out that there is compulsory powers available. I'm not going to enter into the argument about language and coercion and things like that. I don't need to do that.
But is there a distinction between that kind of negotiation towards a settlement by agreement of the objection on the one hand, and on the other, what is described in various pejorative language as something which effectively stifles representations? That is the allegation, perhaps in substance.
Yeah.
Is that the kind of negotiation and agreement that is contemplated in paragraph 26?
Well, the short answer to that is no. There is a distinction. So the point that I just addressed your lordships on is that the guidance says it's perfectly proper to say in default of agreement we'll have to go to compulsory purchase powers.
Yes.
The effect of the agreements themselves, and whether in language that's been used by CS by silence, etc., is, I think, a distinct point. And I'm going to come and deal with the nature and effect of those agreements. But ultimately, it comes back to, are these agreements lawful? My answer will be yes. And two, in the circumstances of this case, did they have any practical effect? And my answer to you has already been no deleterious practical effect. So this.
Right.
So the second contextual point is one we touched on yesterday, so very briefly. There's a basic misapprehension on the appellant's behalf as to the relevance of land ownership in the context of applications for consent for building things, be it under the 2008 Act or the Planning Act 1990. There's no difference in approach to the assessment and determination of applications where the landowner is the applicant or where the landowner doesn't own any of the land. And that's because ultimately a consent attaches to the land, not the landowner. So it simply doesn't follow that where the applicant controls the land, the decision maker may be deprived of relevant information. And under my second heading yesterday, we went to the statutory provisions that ensure information comes forward and is taken into account. And ultimately, if there's information missing, that's for the decision maker. You can either ask for more or refuse. And then the third contextual point, and it's a factual point, but I do repeat that the principles need to be applied to the facts of this case. There were 39 objections from affected parties not withdrawn by the end of the examination. And as the examining authority pointed out, those objections strayed beyond the issues of compulsory acquisition. And I showed your lordship that yesterday. It's paragraph 29.5.10 of the examining authority's report on page 599.
Sorry, 25.
Point 5.10.
Yeah, page.
599.
Thank you.
Core bundle.
Core. 599.
So turning then to the agreements, and I start with the heads of terms. And I do say that there is a tendency in the appellant's submissions to elide the heads of terms and the options agreements and deal with them compendiously, but I say that's the wrong approach, and I'll make that good by looking at those documents. But the starting point is the heads of terms, because on the facts they were the only relevant agreements in play through the examination, and they were intended to define the terms of the options agreements. And one can see that if we take up the heads of terms, which are in tab 2 of the supplementary bundle.
Yeah.
And your lordships have seen this document, so I'm not going to take you through each of the relevant clauses. But if we could just go to page 19 of the bundle. And it says option agreement terms. So looking to the option agreement, the grantor may call for up to 2 easements to be granted over all or part of the option land. Each easement will be in accordance with these terms, and then it's listed out. So it's looking forward and identifying what might be included. And a similar clause that's dealing with the option agreement terms. There's a similar clause on page 33 dealing with the deed of easement terms. And back on page 19, incentive payments, clause 7, notable that they are payable on completion of the option agreement. There's
Sorry,
no,
17,
sorry, 19.
19 again.
My lord, yeah, and it's clause 7 just at the
Oh,
foot
yes.
of that page.
We looked at this yesterday.
Yes, indeed. But I say the only quick point I want to make is no consideration at the time of the heads of term.
Well, as I read it, if somebody signs up to the heads of agreement by the deadlines, but then doesn't complete the option agreement, he gets nothing.
Yes, it's about driving the process forward,
yes.
encouraging them to enter the binding agreement. And I'm not going to take you through the relevant clauses, but I make just this simple point that what is proposed is a package of rights. Ultimately, it's about rights in land. It includes, though, the non-objection clause, which is clause 31, and the confidentiality clause 38. They shouldn't be approached in isolation. They are a small part of a broader agreement that does relate to land. The judge sets out his analysis on the non-binding nature of the heads of terms at paragraph 78 to 80. And I adopt that analysis. It's essentially subject to contract, no consideration, and then apologies, the third point, I ought to have shown you this. So could we go back to the heads of terms and go to page 39 of the bundle?
Page, sorry.
Penultimate.
Page 39, yes.
Yeah.
None of the contacts are intended to form any part of any contract.
Precisely. And then the paragraph below, it says represent the main terms but are not supposed to be fully inclusive and are subject to additions or amendments.
Well, it says, am I misreading this? It says on page 39, none of the contents of this document are intended to form part of any contract that is binding on any Scottish Power Group company. That doesn't say on either party.
It doesn't say on either party, but one has to read that in the context of the whole, back to 17, subject to planning and contract and looking forward, no consideration.
If you're a lawyer.
If you're, well,
Otherwise, if I wasn't a lawyer, I might read this and say, oh, well, they're not bound yet, but
Yes.
I am.
yeah. So that's my learned friend's point, and let me tackle that head on. So his point is, first of all, non-lawyer reading it may think it's binding. Second of all, it sets you on a path, he was saying yesterday, to the binding contract.
Well, and he said, effectively, he said, an accelerated path given the timescale involved.
Yeah, you're incentivized to do it quickly, a path and a short one, given the structures. And so one might feel impeded from objecting. But my response to that is, first, it doesn't properly reflect the facts of this case. No option agreements were entered into in the examination period. But secondly, perhaps more importantly, the interested parties made very clear on a number of occasions that they did not regard the heads of terms as binding. So the examination and everyone involved in it was told these are not binding by the other party to the heads of terms. And can I just give you some references to make that good?
Yeah.
In the judgment, well, let me give you the base references because it's an important point.
Hmm.
So, supplementary bundle, tab 9 and page 137.
Yeah.
This is in a submission dated the 4th of March to the examination. Paragraph 8, halfway down paragraph 8, it says...
Are you sure
Actually,
that
the
date?
24th of February.
It says on the front, does it, 4th of March?
Yes, sorry, this is an appendix to a submission made on the 4th of March. So the entire document is 4th of March.
So
The appendix is a summary of the oral case made at issue specific hearing 9, and that is dated 24th of February. But the force of the point is in paragraph 8, halfway down, the line beginning with 2020, says the heads of terms are not legally binding. The same point is made in tab 12 on page 248. Paragraph 7. It's clear that the heads of terms are not a binding contract.
You've got the further point that's also illustrated in the first of the documents that you've shown us, which is that all of these landowners were legally represented
Yes,
anyway.
Indeed, and that point is made in this paragraph 7 on 248 as well. And rather than tab 15, page 272, sorry, 274.
Sorry, what's the document we're looking at?
So we're looking again at submissions made by the interested party on the 15th of April 2021 to the examination.
Yeah, paragraph.
So 274, paragraph 6, heads of terms, third line, it's not a binding contract. And then goes into the detail of why not. And then finally, just on page 295, again, submission to the examining authority of the 6th of May, page 295, paragraph 3. And again, makes the point about they've got legal advice.
Legal advice. Paragraph? Oh, yes, legal
Yes,
advice.
yeah,
Contract.
sorry, it's the penultimate sentence, yeah.
Well, sorry. It's the final sentence refers to legal advice.
Yeah. So they say the heads of terms are not binding agreements, precursor to further negotiations. Both sets of solicitors
Yeah,
who act on behalf of the vast majority of landowners agree with this interpretation,
yeah.
and it's this basis on which ongoing negotiations have.
You say that makes it clear that they did have legal
Yeah.
advice.
So if someone did fear this prevents me, the interested party has consistently and publicly said, no, it doesn't. And the judge records that in paragraph 165 on Court Bundle 166. And what he says is, he records at 165 in the middle of the paragraph, the IPs repeatedly made clear it was their position from 19th of February onwards that the heads of terms were not binding. And at 166, he goes on to say, all that should have come as good news to both CS and any affected person who might have been concerned about their ability to object. And I say the judge was correct in his analysis.
Yes.
Your lordships have seen the options agreements. I don't think I need to take you to those two clauses. You've seen them and you've got the facts that non-signed during the examination, 2 just before the decision itself, but no material bearing on that decision. And I addressed you yesterday on whether or not the appellant is resiling from the position that it put forward in the High Court, which was that the agreements were lawful, as the judge recorded, paragraph 31, 87, 89, and 122.
Sorry, these are passages in the judgment.
Yeah, where the judge records that there's no argument about the legality of
31, 87.
89 and 122.
Thank you.
So what the focus of the arguments was not legality, but effect and practical effect, sufficient information in that road. But turning to deal with the substantive points that are now raised before this court, I think there's 2 principal points that I need to address. The first is largely in the written submissions from the appellant that concede that agreements such as this are acceptable where they relate to property rights and in the context of compulsory acquisition. The problem, it is said, arises where the objection asked to be withdrawn or not made relates to land other than the landowner's own parcel of land. That's the first point. Objections relating to that go beyond the relevant parcel of land. The second point arises from the oral submissions yesterday, where it was said that Fulham supports the proposition that the starting point is that a contract under which a party agrees to withdraw a planning objection is unlawful because it will tend to interfere with the administration of justice, but that there may be cases where there's a public interest to justify such contracts. And in the Fulham case, that was holding businessmen to their commercial bargains. And I'll deal with each of those in turn. So insofar as the appellant suggests that the principle in Fulham only applies to an objection relating to the relevant parcel of land to which the agreement related, I say that's a narrow reading, not borne out by a fair reading of the judgment. So can we take that authority up, please?
Fulham.
Fulham. So that's AB Authorities Bundle, tab 11.
Yes.
And having established and dealt with the facts yesterday, I think we can go to page 296 of the judgment, which is on 333 of the Authorities Bundle. And in the finding of the Court of Appeal in this case, and I do say it's finding at 333, the third substantive paragraph on page 296. On the other hand, we can see no valid objection on grounds of public policy to a covenant whereby a party to commercial transaction involving the disposition of land undertakes to support and to refrain from opposing planning applications. And such covenants are commonplace, and the rest of the paragraph essentially makes that good. And then
Stopping there, it might be said against you. The party to a commercial transaction involving the disposition of land, so that's the land that's being disposed of, is allowed to enter into an agreement to refrain from opposing planning applications by the other party for the development of the land.
Yeah.
So it relates to a planning application for the development of that land. That's, I think, Mr. Bewley's point.
it is, and may I come to deal with that when I come to Taylor, because that deals with that point head on.
I wonder which way that goes, though. That's simply a matter of impression. For the development of the land, that's the land in question, i.e. the land to be disposed of, yes.
Yes, I think that's the point that's being put to me.
Yeah, but I just wonder whether where there isn't land to be disposed of as such, whether the point has more or less force. How does it go?
Well, I'm going to come to deal with the point that was raised yesterday, which I think arrives or starts from that position, and that's the planning application on the street with the porch, where there is no disposal of land, and I'll come to that in a second.
Yes, no, that was the example given.
Yeah.
Or you might say in a terrace of Dorton houses, where one house has a proposal for an additional floor,
Mansard roof.
and that would be another example. Yeah. Anyway, you'll confront this.
The second paragraph I'd just like to take your lordships to is begins. It's 2 paragraphs down. It begins the principle which underlies both the law of contempt of court and rules governing the immunity of witness from suit. However, is that as a matter of public policy, the court will prevent, and if necessary punish, conduct which interferes with the proper administration of justice. And the focus in this case is on section 2 of the Witness Public Inquiries Act 1992, which leads to the focus on administration of justice. But I addressed you yesterday on the importance of recognising the nature of this decision, which is an administrative one in the public interest. But nonetheless, the questions that this consideration gives rise to and articulated by the court here are elucidating in this context. And so the court goes on and says, in any individual case, therefore, the question is, has the act impugned, interfered with, or will it interfere with the due administration of justice? It's not merely sufficient to pose the question, is the effect of the agreement that a party or a witness may be prevented from putting forward a particular contention in court or before the tribunal? Translated into the current circumstances, it's the question is not, is there any more information out there? As I said earlier on, is there sufficient information to take the decision in the public interest? Over the page at 297, the court specifically approves the Taylor and Chichester and Midhurst Railway Company case. And that is a typical railway case where there was an agreement with the landowner for the purchase of some of his land through which the railway was proposed, including an agreement for him not to object to the scheme and certain payments in light of that. And ultimately, the railway didn't happen. And Taylor said, I'd still like my money. And so there was an argument about whether the contract was enforceable. And it was. But the point in that case is that the objection from the landowner related to the scheme and not his particular tranche of land. And this is a linear scheme in that case, a railway scheme. And in such schemes, it would often be the case that it involves many individual landowners, some of which will have multiple parcels, potentially very small, not necessarily contiguous. In my submission, it's artificial to suggest that a landowner with particular parcels have to preserve their ability to object to such a linear scheme other than in relation to his land. Such an approach would make the non-objection clause worthless.
Did they address this specifically in Taylor?
No, not specifically. It was about the enforceability of the
Well,
contract.
because there were lots of other different issues. And I mean, it seems that Taylor's objection or proposed objection was the damage to his own property rather than anything else. So although you're right, you can read it in a broader sense.
Yes.
Nothing specifically was said by in that authority to that effect, was there?
That is fair, my lord. You can see if one turns up that case, page 185 of the bundle behind tab 8.
Right, yes.
The facts are laid out on page 186, and if one looks at the line 8 down, halfway across, it says on the 17th of February 1865, articles of agreement were drawn up between the parties which recited the above facts, and that the line of the proposed railway will pass through the property of the said Charles Taylor in such a manner as to interest and seriously damage the same. He has accordingly intimated to the company his intention to oppose the bill. So it was opposition to the bill as a whole, but for that reason.
Yeah.
But
Where is the basis for the decision in that case?
the key passages from on page pages 637.
Right, so this is the Lord Chancellor, Lord Hatherley.
My lord, yes. And at 195 of the supplementary bundle, at the end of the first paragraph, it says, the agreement therefore is framed partly on the consideration of the property which he agrees to sell in the event of the act passing, and partly also in consideration of the withdrawal of his opposition to the intended bill.
Yeah. Is that a parallel situation to the present case?
In my submission, it is. The objection pertains to the bill as a whole, albeit in that case it did arise directly out of damage to land owned by Sir Charles Taylor.
And the legal issues were all completely different.
Completely different, because they're about, can he enforce it now that they're not carrying on with the array?
Yeah, and were there trusts and all sorts of things? Yeah.
So the outcome, the disposition, if you will, or disposal.
He got his money.
He got his money. Oh, sorry. Yes, sorry. He got his money in short. Yeah, yeah. He succeeded. He succeeded.
Right.
And looking at the issue through the microcosm of the land owned by a particular objector isn't, in my submission, the correct lens in the context of determinations of planning applications, which are blind to land ownership and are determining what is right in the public interest.
Well,
Mm.
up to a point. Take the point that planning is nothing to do with land ownership, and we just look to see whether it's a justifiable development. But in this case, I take the point that he's objecting to the development consent, or in this case, the bill as a whole. But the reason he's objecting to it is because of the impact it's having on his land.
Yes.
And likewise, it might be said with somebody who is potentially going to have their land purchased as a matter of compulsory purchase if he doesn't agree, that he's objecting to the planning consent generally because it's going to ultimately mean that he's going to lose his land or have an easement over it or whatever it may be. And in that case, you can see a direct connection between the clause that says you withdraw your objection and the reasons for the objection and the planning consent generally. So whether it's an objection overall to the planning consent or just to his land being included within it, it really doesn't matter. Where I think one gets a little bit more, it gets a bit more tricky, it is where the person concerned has got a principled objection to the scheme on grounds that have got nothing to do with the fact that his land is going to be affected by it. So he is the greatest supporter in the area of the marsh harrier, to take the example we were discussing yesterday. And therefore, independently of whether his land is going to be affected by it and whether anything can be done to sort out the easements over that, he still wants to oppose this scheme root and branch because of the impact it's going to have on the ecological site. Now, that I think is Mr. Bewley's point, which is you can legitimately, for business purposes, say, well, the planning is part and parcel of the price that you pay. Withdraw your objection to the planning application as a quid pro quo for getting paid or compensated for the impact it's going to have on your land generally. But why should you be able to say commercially, we're also going to stop you jumping up and down because of the impact it's having on the marsh area?
Two principal responses to that. First, issues that in the context of the Planning Act are relevant and important are seized in the decision maker.
Yeah.
So they survive the removal of any objection.
And you've got the EIA and so
We've
forth.
got the EIA to protect that statutory structure to protect decision making and ensure there's enough information. And then secondly, there are decisions for landowners to make. Any agreement is entered into freely and knowledgeably by a landowner, and they can elect not to enter into those agreements. So there's no public interest in interfering with contractual agreements between parties freely entered into it. In particular, in the wider context of the statutory framework for decision making that ensures enough information is before the decision maker.
So I don't want to cut across. Just want to come in on that particular point. And maybe my lady wants to come back on what you said. The voluntary element in the agreements you say is significant in this context.
Yes, they are agreements that are entered into by two parties freely.
As opposed to at the extreme, I suppose, an arrangement entered into under duress.
Yes.
of some nature. We're not in any
We're not in that zone.
territory close to that.
See Dr. Jimson.
But you said there are decisions for the landowners to make, which was the way you put it. They can elect or not to enter into these arrangements. You said that is an operative factor in the overall analysis about the administration of justice.
Yes.
And that comes back to Fulham, of course, because Fulham talks about commercial bargaining power.
Entirely same, I think. Yeah. So what I say is the principle to be derived from Fulham ultimately is so if you still have Fulham open, tab 11 of the authorities at page 334. And in the middle of that page, where a new paragraph begins, it says the court will consider. So the court will consider the facts of each case, yes, but the starting point is, but whereas here, a commercial agreement relating to land has been entered into between between parties at arm's length, and one party agrees in return for a very substantial payment to support the other party's application for planning permission, we can see no rule of public policy which renders such an agreement illegal or unenforceable. And that is, I say, the starting point. Yes, apply it in the particular factual context. So it might require adjustment, but that is the starting point. And that's the inverse of my learned friend's submission to you. And I say there's no good reason to interfere with that principle as articulated in Fulham. Can I then just deal with the porch in the street? Just very briefly. The point of that analogy was to take it out of the compulsory purchase world and ask the question in a pure planning context. My first point has to be, well, that's not the factual scenario we're dealing with here. And I've already said there are no agreements in place. But putting all of that aside, it does raise the question of where you draw the line. So in the debate yesterday, it was posed, is it okay to compensate for a fall in the value of the neighbouring home? Because that would relate to land. Is it okay if it pays, for example, for soft landscaping so that the neighbour can live with it more easily, some form of mitigation to ameliorate the effect? How would you know what contracts were lawful and which were not? How would the parties coming to the contract identify that? It's, in my submission, going to be a recipe for confusion, and there's no need to create that uncertainty because the correct starting point is as per Fulham. They're not inherently unlawful, they're fine, apply in the particular factual context. But also because, and one returns to it, the administrative nature of the decision. And it's the decision maker that evaluates the merits, and it's the decision maker who will be seized with the question of whether the impact on the street scene is acceptable or not. And he will do that in light of being satisfied he has the information to do that or not. So it comes back again to the nature of the decision that is being taken. It's a merits decision.
Another bright line would be you can't do it unless you're getting an interest in land, and you don't need to worry about any uncertainty. And why? Because frankly, bigger people with more money can then bully what they want.
We are dealing with it in that context.
Yeah,
I don't think the court needs to go on and deal with the porch in the street, but it illustrates the potential problems. Can I then finally just deal briefly with discretion, because I do rely on section 31(2)(a) of the Senior Courts Act.
Yeah, I just wonder whether, I know that it gets called discretion, but
Yes, maybe I shouldn't.
it's duty in certain circumstances.
I'm grateful, and
It's
yes, I
not,
should call it.
it's not of the same nature as the simplex style discretion.
that-
It is a duty that's imposed by statute upon the court, where the court reaches a particular conclusion about the likelihood of an outcome.
My lord, I entirely accept that, and
Yeah,
that's
I
a
know,
correct
sorry, but
characterisation.
Perhaps I don't need to say it, but I think that's important to keep in mind.
I correct my heading. So my primary case is we don't get to this point because the conduct complained of discloses no error of law. But even if that is wrong, I say relief should be refused on the basis of section 31(2)(a). The context is that the appellant can't identify any information that's been left out of account, or really what steps the respondent should have taken. So in response to that, my learned friend says, well, the burden of proof is on the respondent in the context of section 31(2)(a). I accept that. And so the appellant goes on to say the respondent can't prove a negative, i.e. that no information was left out of account. But it's important to accurately reflect the nature of the test. What one is seeking is high likelihood. Yes, that's a high hurdle, but it's established in the authorities that it's somewhere between the civil and criminal standards of proof, somewhere between balance and probabilities and being sure. And that's an attainable hurdle. And just for your Lordship's note, that is set out in Carver BN, paragraph 52 deals with the proper approach to section 31(2)(a), and 52 Roman 3 deals with the burden of proof. And I say in this case, we discharge that burden of proof where about 80% of the landowners, very roughly, objected. The 39 out of 55, so a bit less than 80%. There was an in-depth 9-month examination, 880 relevant representations, so massive public participation. I showed your Lordships yesterday the long list of statements of common ground with statutory consultees, Natural England, Environment Authority, so huge engagement with statutory consultees. And that was page 582 of the core bundle. And an ES produced as required by experts. And I do say also that the context I gave you, they've identified no information that's missing, is important because in the context of section 31(2)(a), you can, albeit carefully, look backwards, and no one has come up with any further information. And for that, I rely on paragraph 5210 of Carver BM. And so in all those circumstances, and recalling the test doesn't require certainty, it's somewhat short of that, it can be found that it's highly likely that any further information arising from another call for evidence would not make a substantive difference to the outcome. So unless I can assist you further, those are my submissions.
Right, thank you. Jeremy? Thank you very much, Mr. Westman Smith. Yes, Mr. Philpott.
May it please your lordship, mindful of the time, I just want to say I suspect, to give Mr. Bewley a proper opportunity to respond, I think I may need more time than would allow for completion by the lunch adjournment.
Understood.
So, although for reasons I'll explain, I'll try and be reasonably brief. I suspect I may be about an hour.
Yes, well, I think you said an hour yesterday.
Well, if I can start by saying on behalf of the second and third respondents, I endorse and gratefully adopt the first respondent's oral submissions. So I don't propose to repeat those. My submissions will cover the following points. First, in relation to the facts, there's one short point on the approach to findings of fact, which I just want to add, together with a couple of references to the factual material. And then moving on to the grounds, I've got 4 headings. First, the appellant's case in the Tameside context. Second, what I describe as the appellant's volte-face on the lawfulness of the agreements, and my response to its case on that issue as it's now put. Thirdly, a short public law categorisation issue. And then fourthly, one short additional point in relation to section 31(2)(a).
Right.
So I propose to start with the first point, the approach to the findings of fact below.
Right.
My lord, in this case, we say that the alleged errors of law are fact sensitive because they engage issues of judgment for the decision maker, particularly where we say the lawfulness of the exercise of that judgment is to be determined on Wednesbury principles. And the specific addition that I want to make to the points made by my learned friend about the approach to the findings of fact below in those circumstances is this. It arises from phase, which we can turn up if necessary, but I take from yesterday's indication it's very familiar territory.
Yeah.
And it's that the approach that's set out in authority about how this court deals with findings of fact below is not limited to findings of primary fact. It includes also the evaluation of those facts and the inferences to be drawn from them. Just for the reference, that is paragraph 114 of Phage, which is 485 of the authorities bundle. And we say, in this case, that's of particular significance when it comes to what was said by Mr. Justice Holgate about the thrust of Sayers' case as put to the Secretary of State. And if I can ask yours to look at the core bundle, and in the judgment, which is at tab 12, to page 169, and paragraph 184 begins at the bottom of that page. This is the culmination of the reasoning in relation to ground 2, and the judge sets out the conclusion at the beginning of that paragraph. Having reviewed all the material before the court, I'm left in no doubt that the allegation by Sayers that the IP's conduct discouraged affected persons from making representation to examination was not an obviously material consideration. And then 5 lines further down, there is the part of the explanation for that conclusion. The thrust of Sayers' criticism was concerned with irreparable unfairness and then explains that was rejected. Now, that finding about the thrust of Sayers' criticism is either a primary finding of fact, or at the very least it's an evaluation of the facts or an inference to be drawn from them. And the way that that point was put to the Secretary of State is of obvious relevance to analysing the lawfulness of how he then grapples with it in his reasoning. And the finding at paragraph 184 of the judgment is the culmination of a detailed consideration by the judge of all of the lengthy and detailed submissions that Sayers made both to the examining authority and to the Secretary of State, and how they evolved over time. And that's set out at paragraphs 90 to 130 of the judgment. And of course, it's an appraisal of those documents informed by detailed skeleton arguments and 2 days of submission, whereas the judge records most of the attention was on those facts. If nevertheless the court wants to form its own view as to whether the judge went wrong on those facts, I don't propose to go through all of those in detail. Importantly, the court now has the complete version of the Sayers submissions of the 7th of October 2021 and the passages to which Mr. Justice Holgate referred. And I would simply invite the court to look at those, and in particular the way that the emphasis on procedural unfairness is set out at length in the passages to which the judge refers. But there is only, I said there was one small point of fact that I wanted to then draw attention to in addition to those that Mr. Westman Smith has dealt with, and it's simply this. If we can go to the Sayers deadline 8 submission, which is in the supplementary bundle at tab 11. And these are submissions these are submissions which were made to the examining authority during the course of the examination. And if one goes to page 192, and then from Mr. Westman Smith went to paragraph 122 on this page, but I want to draw attention to paragraph 121, which the judge also considered to be important. Sayers notes in the procedural decision, the examining authorities indicated that an option open to it is to address these matters in its recommendations to the Secretary of State. Sayers considers that this is the correct approach to adopt. In other words, they were not saying to the examining authority, we want you to conduct some sort of exercise here in order to get to the bottom of this. That, as you all should appreciate, is quite different to the way that the point is now put before this court when asked, well, how on earth is this issue to be addressed? The only way forward is action by the examining authority. That's not what was being said to the examining authority at the time. So I then turn to my second heading, which is the appellant's case in the Tameside context. In other words, as the judge, we say, correctly approached it. And the first point that I want to make is that the Sayers case below, certainly so far as this issue is concerned, was put squarely in the context of Tameside. And that can be seen, three references to go to here. The first is in the skeleton argument that was put in on behalf of Sayers, which is in the core bundle at tab 14. It starts at page 176 the parts that I want to refer to are on pages 193 to 194. And what one can see straight away from paragraph 61 and the heading that sits above it, and then the identification of the relevant authorities dealing with the Thameside duty, and then submissions on the following page made in that context. Now, my Lord, in order then to understand how matters evolved, one needs to go to the judgment, which is behind tab 12, because it page 133, paragraph 35, as a result of discussion with Mr. Wolfe, the grounds relied on by the claimant are as follows. And that reflects a discussion which I think my learned friend Mr. Bewley refers to as arbitrage in his skeleton argument. But it was effectively the judge clarifying, with the assistance of leading counsel for the claimant, what are the grounds that are in fact pursued. And over the page, ground 2 is a failure to investigate, and that's the Thameside ground. Well, I would go further and ask the court to go back in the court bundle to the order of Lord Justice Singh. This is tab 7, page 97 of the bundle, and to paragraph 2, where the central issue is identified there. Central issue is whether the Secretary of State acted unlawfully in dealing with a complaint the interested parties had stifled and utilised the ability of landowners based on possible compulsory purchase. That is indeed the central issue in this case. It appears to be recognised in the way in which the issue of public law arising set out in paragraph 12 of the applicant's skeleton argument supported the present application. There's a duty upon all decision makers to take all reasonable steps to ensure their decisions can be taken on the basis of the fullest possible relevant evidence. That is a Thameside allegation.
Could you just read on?
Yes, of course. Where a party with a vested interest in the outcome of a decision makes secret claims to potentially important witnesses, prohibiting them giving evidence, generally enabling that party to control the evidence that might otherwise be given, is a culpable risk to the integrity of the decision-making process of public interest. But that's the issue which was said to need to be investigated. It's put in the Thameside context, and the correct approach in law as to whether a Thameside complaint about a failure to investigate is set out in the judgment at paragraph 69, drawing on the authorities identified in paragraph 65 to 68. And so far as a Thameside test feels to be applied, I don't understand that description of the law to be controversial. There's an issue as to whether this is a Thameside case or not, and I'll address that. But if it is a Thameside case, that summary of the law I don't understand to be in dispute. The approach that the appellant now takes, and the change in its case that I'll come to in due course when I turn to the question of Fulham, is to seek to avoid the obvious implications of that legal test for its complaint by saying, well, the normal Thameside principles don't apply. And the difficulties, those obvious implications that I submit, can be seen just by looking at the appellant's skeleton argument. So this is behind the core bundle behind tab 3, and page core bundle page 37, paragraph 69. The last two sentences. The first sentence is the obligation to at least understand what the issue was, and I've dealt with that. But then it says this, further in the submission of the appellant, the Secretary of State was required to take steps to satisfy himself as to the extent of the problem and or seek to remedy that problem. But note that the argument proceeds implicitly from the assumption that this was in fact a problem, so as to trigger the suggested obligation. That, I submit, is no more than a rewording of the submission made below and rejected by the judge at paragraph 28 of the judgment. So on page 132 of the core bundle, where Mr. Justice Holgate says the court is faced with paragraph 40 of the claimant's skeleton argument. It is, of course, not the function of the court to rule upon the allegations and evidence, as above, that the claimant put to the examining authority and addressed to the Secretary of State. The court merely needs to proceed upon the basis that a serious complaint was made, which needs to be investigated. The language now is the problem, but it's exactly the same point. It's just reworded. And once the SEAS issue of procedural fairness had been dropped, in other words, it was not picked up as a ground of challenge, as that was not therefore going to be pursued in judicial review, the only potential life in the point was that it might be a potential material consideration going to the substantive decision. It's no longer a point about fairness. It's no longer a procedural point. It becomes a substantive point, if it has any life at all. Thus, it takes you into the question, was this an obligatory material consideration, which is the way that the judge correctly understood and addressed it. But returning to the way the point is put at the end of paragraph 69, is that there was, until yesterday, a complete lack of clarity and specificity as to what steps were necessary, even in broad terms, or how the problem, as it's put, might conceivably have been remedied. And the appellant has never been able to either identify what type or level of further investigation by the decision maker was required, and that is still the case following yesterday's oral submissions, nor has it identified any specific further information it says the Secretary of State was obliged to seek, not just that which was missing, but what further information was the Secretary of State obliged to seek or obtain pursuant to that investigation, or what the Secretary of State should have done with that information to remedy the alleged problem when SEAS has consistently said the problem is irreparable. My Lord, at this stage I simply make the submission that if the court decides that the Tameside legal principles do apply, and that in the circumstances of the case, Mr. Justice Holgate was right to conclude this was not an obviously material consideration, then it's of no legal significance that the decision maker did not consider whether to pursue lines of inquiry about it. Now, in oral submissions, Mr. Bewley did eventually appear to confirm on his analysis the Secretary of State had no means of resolving the problem by the time it reached, the examining authority's report reached his desk. That was my understanding. And then we got into the point which my learned friend Mr. Westman Smith has addressed, which is, well, the examining authority should have made some ruling and adopt those submissions. But
it's not my position the Secretary of State could not have done anything. My submission was I could see that the Secretary of State was in a more difficult position if the examining authority didn't seize it earlier on. But I didn't go so far as to say there was nothing that could be done. I just want to.
All right.
That's certainly how I understood the submission I was making.
Understood.
Well, where it goes, I don't know. But I don't want to be.
just for completeness, if your Lordship has my learned friend's skeleton argument open,
Yeah.
Turn to page, core bundle, page 38.
Yeah.
Paragraph 74. This in itself put the Secretary of State in a difficult or impossible position in terms of his own ability to reach a view on whether he had adequate information.
Well, I apprehend that Mr. Bewley is emphasising the word difficult.
Yes.
That's exactly right.
But then we come to the question, well, what's the practical answer?
Yeah.
It's no good in my submission, as Mr. Justice Holgate accepted, for the appellant to come to this court and say there was a failure in the Thameside duty if it can't even identify in broad terms what sort of investigation was needed. That rather points to the hollowness of the underlying complaint. All unspecified, all vague. But that flaw is exacerbated by the fact that at the time, in other words, in the run-up to the decision, SAS was telling the Secretary of State there was no point seeking to cure the problem now, the decision was in his hands, because it was irreparable, and that seeking more evidence either from my clients or more widely would compound the problem. And there are two references I want to go to there in the supplementary bundle, just to make that point good. So in the supplementary bundle, we put in some additional pages behind page 349.
Yeah.
So this is tab 19.
Yeah.
So those pages are numbered 349 and then letters after them. And if one goes to page 349T, so pages 349T to 349U, there are two headings: procedural defects cannot be cured, and then that's reflected in what's said in 123, and then 124. If one looks at the second sentence, can't be retrieved now, no way it can be remedied after the event. And then no right to second chances. So 125 and 126 is directed at my clients. The end of 125, no principle entitles applicants to second bites of the cherry. As already observed, if SPR seeks to produce additional and new evidence to Secretary of State, this will compound the procedural unfairness that already exists. And then going on to the subsequent submission behind tab 20. So this is a request. This is a response to a specific request for further information made by the Secretary of State to various parties. And if one looks at page 353, paragraph 2 identifies the fact that the request seeks information related to a range of evidential matters affecting the suitability of the Friston site. That's a substation site. Paragraph 3, we are compelled to put on record a serious objection to the manner in which this request has been made. And then paragraph 6, we have in all our evidence provided chapter and verse explaining how and why SPR has succeeded in preventing the examining authority from being able to collect full and fair evidence. And then it goes on. But then paragraph 7, one fact we've drawn the attention of the Secretary of State is under the heads of terms used to gag landowners, prevent them from participating in inquiry, restriction on giving evidence extends beyond the planning stage and covers also submissions to the Secretary of State, such as are now sought by the present request for evidence. And then it goes on to explain in 8, 9 and 10 why they say that's a problem. Looking at the last sentence of 9, the present request will not be responded to by those landowners for exactly the same reasons. The request therefore perpetuates the deep unfairness. And then paragraphs 11 and 12, the threat of challenge. And so one can see there that not only has the appellant not pointed to any particular steps that the Secretary of State should have taken, but that was flatly contrary to the approach that it was taking to the post-examination submissions, where it was saying, don't give the applicants any chance to put anything more in, and if you ask interested parties, you're just perpetuating the problem. Well, I want to then turn to my next heading, if I may, which is the appellant's volte face on the lawfulness of the heads of terms in the option agreements.
Yeah.
The court has been taken to those places in the judgment where Mr. Justice Holgate records the clear concession made by leading counsel on behalf of the claimant that we're not arguing that the heads of terms and option agreements were unlawful policy. We've gone to those. Unsurprisingly, therefore, at first instance, SEAS did not ultimately invite the court to distinguish Fulham and find that the agreements were illegitimate. Now, it's important to see that in context. First of all, could we go to the core bundle for the interested parties' detailed grounds of defence. So this is tab 18, or detailed grounds of resistance. And page 271, full bundle page 271, paragraph 25, where we had in our detailed grounds explicitly referred to and relied on this authority as being relevant to the grounds of claim. So Fulham relied on clearly part of the case that the claimant would have to meet when it came to court. And one could turn this up if one likes, but certainly I haven't been able to find anything in the appellant's, the claimant's skeleton argument at first instance, which is at tab 40, that mentions Fulham, let alone seeks to distinguish it. But it is worth turning it up for one point to understand why that might be the case. And this is so this is behind tab 14, and it's page 189. At paragraph 40, under the heading "Role of the Court." So the way the point was put is that it is, of course, not the function of the court to rule upon the allegations and evidence as above that the claimant put to the examining authority and addressed to the Secretary of State, and then there's you just need to proceed on the basis of a serious complaint. And so effectively, the approach at first instance was to say, well, you don't need to, we're not going to argue that, you don't need to make a decision on it. You just have to assume there was a serious complaint. And the judge below, we say correctly, didn't accept that was right, and dealt with the underlying point of law head on. So the argument now before this court, that contrary to what's said in Fulham, such clauses are not legitimate, represents a volte face on the legal arguments that are being put as to why the Secretary of State's decision was unlawful. And going back to the judgment, if I may, because there's a broader point at play here, page 132 of the judgment, paragraph 26, where the judge records the clear statement on behalf of the claimants that there were no allegations of procedural unfairness, let alone unfairness of an incurable kind being advanced, and then it explains the way it is put, and then records this was a volte face in the way in which the claimant maintained its complaint throughout the examination and subsequent representations to the Secretary of State. So the way the case was argued before the judge below was recognised as being a volte face in the way it was put before the Secretary of State.
So this is a further volte face.
This is a further volte face, but it reflects a series of about turns. So first of all, during the before the decision, all the legal focus was on procedural unfairness. But clearly, at some point, before the application was in fact challenged, it was recognised that was a dead end, and therefore that was not pursued. It was also, I say, it can be inferred it was recognised at first instance that there was no proper grounds for distinguishing Fulham, and so it's best to recognise that there was nothing in principle illegitimate about the clauses, and that therefore it should be a Thameside challenge. That hit a dead end, and for the reasons I've explained, continues to hit a dead end. Hence the further volte-face, which is effectively forced to say, right, well, we'll go back to Fulham, and we'll now try and run it on a different basis. Now, we've set out in our scars and arguments why we say that the new basis can't work, paragraphs 61 to 65, and I don't propose to repeat Mr. Westman Smith's submissions, but there are just a few points that I want to add to it, if I may.
Just pausing for a second. You use the language of volte-face, which indeed the judge uses, and I hope this isn't merely a pedantic point. A volte-face means an about-face, which suggests a 180-degree turn. Volte-face upon volte-face represents a 360-degree turn. Do you mean two changes of direction which do not quite bring the point of attack back to where it started?
Your lordship has it, and it is an important point, because otherwise we'd be back to procedural unfairness.
That's right,
and we're not. So it is. I put it in a way which might have superficial attraction, but I recognise that your lordship won't characterise it.
It has the beauty of avoiding the French as well, because one could simply say a further change of direction is your submission.
I'm content with that, my lord. I don't seek to insist that it is too volte-face, because it doesn't take them back to where they started. So, my lord, if I can just deal then with some further points in relation to Fulham, and if we go, please, to tab 11. And to introduce these points, the learned friend Mr. Bewley relies repeatedly on an encouragement to the court to read between the lines.
Yes.
And I say that's not appropriate. One needs to look at what the court said. Mr. Westman Smith has dealt with the point of principle, and we also say that there is a point of principle here. But I want to return to the top of page 333. This is within the bundle, so it's page 296 of the original, to a passage which Mr. Bewley focused on, and it's the first paragraph on that page. And it bears looking at again. It was submitted that the effect of the covenant, if in force, would be to prevent the plaintiffs from putting their true views as to the merits of the current planning application before the inspector. That was objectionable and illegal. Just pausing there. That is very much the same sort of argument that is advanced here. It's not just a commercial point. So we'd be stopped from putting our true views before the inspector. And then it continues, furthermore, as the first plaintiffs have now decided that the Vicentia application is not in the best interest of the club, any evidence which suggested the club still supported the application would be false and might be perjured. Now, there are 2 points to be made there. First, it's a furthermore. It's not all about this second part of the paragraph, but the context is that the provision in that case was that they would support, but they this was, just for your lordship's reference, page 325, clause 5, saying that they support the same. But the substantive point is that what's in the best interest of the club and whether the club supports the application is not simply a matter of private commercial interest. It is also necessarily something that engages planning matters, because a football club, a popular football club that draws in a significant number of visitors and spending to a local area, that provides an important amenity and economic benefits, if the club is going to be displaced and it supports the application, that is potentially a material consideration in planning terms. Otherwise, there'd be no point in trying to get the club to actively support the application and to put in submissions to that effect. This is not, therefore, a planning neutral point, if I can push it in that way. And the argument made about the role of the wider public interest in planning decisions, preventing people's true views being known to the planning inspector, these are essentially similar, if not the same sorts of arguments that are being put forward now. Now, we then have the question of, well, if they're not always unlawful, how does one seek to draw a line? And that one suggestion has been that it should be limited to objections which relate to the land within that landowner's ownership. I say that that is not only not what Fulham is saying, but it's also not a practical real-world proposition. There's nothing in the court's reasoning in the Fulham case to suggest that such a clause is only contrary to public policy if the red line boundary for the application does not extend beyond the contracting party's land ownership. If that was thought to be the point of principle, there would be, one would expect, some more detailed consideration of it. But what the court found is expressed by reference to planning applications. So if one looks at page 333 and the third paragraph on the other hand, and what is being engaged here undertakes to support and to refrain from opposing planning applications by the other party for the development of the land. Its planning applications support or oppose, refrain from opposing those. And similarly on page 334, the second complete paragraph, whereas here, commercial agreement relating to land has been entered into between parties of arm's length, and one party agrees in return for a very substantial payment to support the other party's applications for planning permission. It's non-opposition to the application which is an issue and found to be legitimate, and that's consistent with the way that the matter is put in the guidance from the RICS, which we've referred to in our skeleton argument at paragraph 64.
Can I just ask you on that passage that you took us to just now, 333, because you're right, it does say the planning refrain from opposing the planning application, but it does qualify it before involving the disposition of land.
Yes.
And the over the page is also a commercial agreement relating to land.
Yeah.
So does that mean that you couldn't do the porch example? It has to be, you can only impose this sort of clause on someone if you are selling an interest in land.
Well, on those matters, essentially our position is the same as the Secretary of State's. And the first point is on the facts of this case, that all the contracts relate to the disposition of land. So the issue doesn't strictly arise to be determined. But if it did not, then there would need to be some sort of nexus between the agreement, the consideration, and the planning application question.
I was simply going to ask this. I mean, is the principle actually just slightly in a different place? Is the principle really that one elicits from this judgment that it is on the facts of the case that one has to consider whether the entering into of such an arrangement, whatever that arrangement is, does or doesn't have the effect of, for want of a better expression, interfering with the interests of the proper administration of justice, to use that expression. And that is the principle. I mean, there isn't to look further for a principle is a false journey. Is that how you put it?
Well, subject to one caveat,
Yeah.
which is that the point of principle which is expressed on page 334 is related to a commercial agreement relating to land. So
Well,
it's
is
not,
that-
it's what,
Yeah.
the reason I stress that,
Yeah.
it's not simply that each time the court comes to look at it, it has no guiding principle at all. Because in principle, whereas here, although it's not just on the facts, but where, as in the facts of this case, those circumstances arise, there's no rule of public policy which renders such an agreement illegal. So you don't start from a blank sheet. If you can bring yourself within that rubric, one would need to find something else.
Well, it's
Which
the
took you on
paragraph
the
very
back.
deliberately starts with the court will consider the facts of
Yes.
each case, and that we shouldn't overlook that first sentence of that maybe crucial paragraph.
But and my submissions do not.
And indeed, Lord Justice Neal comes back to that concept, the facts of this case, about 8 lines further down.
My Lord, I don't doubt that at all. But the point of principle, which is identified in the second sentence, starts with the word but.
But whereas here, yeah.
Whereas here, so if one brings oneself within that that characterisation of the principle that's established through that case, there would need to be something else on the facts that took it outside
Yeah.
that general category.
That ties in with what's said on page 333. You've got an agreement of this kind which is commonplace, and there's nothing more objectionable in it than what is objective about, if you like.
I mean, the but there isn't a contradicting but. I don't think it's a contextual but.
It is.
If I can put it like that.
In other words, but importantly, coming back to the way I characterise it, my Lord, if I may, it's a but that reflects the fact one is not starting from a blank sheet.
Yes. It is to go on and deal with the facts of this case.
Yes. And where, as here.
Yeah, well, that's the force of as here.
Yeah.
But whereas here, and the judge is going on as he must to deal with the particularity of the case in front of the court.
Yeah. But the effect of the appellant submission is to reverse that. Is to say that you start essentially from the blank sheet, that you don't pick up that point of principle.
Well, that brings us back to the starting point of my question: what is the principle?
Yeah. But, my Lord, the other element which I just want to draw attention to in terms of how this sits with the appellant's argument, can I ask your Lordship to take up the appellant's skeleton argument at, so this is into now the core bundle. And there are 2 passages in here which I want to address. The first is at core bundle page 35, and it is paragraph 62. So this is where my learned friend seeks to recognise the legitimacy of an agreement based on a planning objection, he says, founded upon the relevant property right. I want to return to that concept in due course, but taking it at face value for the moment, recognised there as being legitimate in the context of Fulham, and then submissions made about how one can't extend that. But if one goes back to paragraph 59, and what is said in principle to be illegitimate, it's for a party or participant to influence the outcome by making payments to a witness or a participant for the purpose of influencing the evidence they give or prevent them from giving that evidence. it's taking that point of principle. There appears in my respectful submission be a mismatch between the two, because if in principle such a clause is objectionable, it's no less objectionable in principle simply because the objection that would otherwise come forward, or the information or the evidence that might come forward, relates to the part of the land which sits within the red line boundary.
That's why I think Mr. Bewley says that there's two competing public interests that you have to balance out against each other. And that on the one hand, you've got a public policy objection to preventing somebody giving the evidence, and on the other hand, you've got another public policy driving consideration, which is to hold people to their commercial bargains.
Yes, but the difficulty, my lady, is this. When it comes to establishing that as a principle which governs the legitimacy or otherwise of a contract, what if the bit of land within the red line boundary that is owned by the objector is really important for the purpose of the merits? In principle, that would be illegitimate. If evidence, say it was a special protection area, a European protected site, where it contained some important species, it contained something which really went to the heart of the application on the merits. On the learned friend's approach, whilst in principle that would cause problems in terms of paragraph 59, potentially quite acute problems, that would apparently fall on the right side of the line. It's not, in short, a sensible way of seeking to draw a point of principle that will determine whether people should be held to their bargains or not, whether it's a legitimate contract or not. Similarly, the point raised in response to questions about this in submission yesterday, which is that it would be legitimate if a landowner had been unreliable in negotiations. Well, how is one meant to judge that? And who decides and when? Is the examining authority to decide? Is the Secretary of State to decide? That apparently is the appellant's case. And on the basis of what evidence? Full disclosure of all negotiations to decide whether in each case the landowner was being sufficiently unhelpful and unreliable? It's not a sensible ground of distinction for when these are or are not legitimate in terms of public policy. And all of the concerns about the real risk of relevant information or issues not coming to light would apply equally, potentially, in a case where the land that the landowner holds is of particular importance to the merits.
So then where do you say one draws the line? Because one can well see that concerns would be raised, for example, about the developer going to the chair of the local protest group and saying, I'll pay you £20,000 to back off. I'm giving you an extreme example.
Well, Melody, that, assuming for the purposes of context that the person had a relevant landholding that needs to be acquired, I'm assuming that's part of the example. It's not purely gratuitous.
No, it's purely
Well,
gratuitous.
in those circumstances, first of all, it would fall outside the rubric of Fulham. It would be a different type of case.
It would.
It's not the type of case here. And I don't have to seek to establish any principle that would apply more generally. I'm dealing with the facts as my client dealt with. My client did not seek to enter into such agreements.
No, you're saying your case is on all fours with Fulham, as I understand it.
Indeed.
But I was really asking you from the point of view, you've made the perfectly valid forensic point, that if you draw the line where Mr. Bewley wants to draw it, it creates uncertainty and difficulties and so on and so forth. So I'm simply exploring, how far does one draw the line? Are you saying that the Fulham principle applies in all cases where you've got a disposal of land by a landowner whose land is likely to be affected by the proposal, and any objection that he raises to the planning application as a whole is therefore it can be part of the bargain that he withdraws those objections? That's basically
Yes,
it.
exactly.
Yes.
If that is the point. This is a negotiation.
Yes.
This is a negotiation between parties who are both legally represented and represented by experienced land agents. All the terms, including, as your ladyship has seen, the scope for maintaining objections, are subject to negotiation, and seriously and actively so, as the evidence has shown. But if a party enters into such an agreement, its statutory right is unaffected. It can still object, but it's chosen, judging where its own best interests lie, with the benefit of legal advice and commercial advice, not to exercise those rights in return for certain benefits which reduce the adverse effects of the proposed acquisition and development on that person. And if I can just draw attention in this respect, it's important to understand the nature of the option agreements. And in our skeleton argument at page 71 of the bundle, page 4 of the internal pagination, paragraph 16, we start dealing with the heads of terms, but 16.2 deals with the negotiation of the formal option agreements, and we explain that the purpose of these is both to provide my clients with the rights required to deliver the nationally significant infrastructure, but also to provide the landowners with rights and benefits in terms of compensation and arrangements regarding works and mitigation. They are a framework to enable a positive long-term relationship between the parties. Because as will typically be the case, when works are being undertaken across a party's land, particularly if it's, say, temporary construction works to install some linear infrastructure, there will be disruption, not just at the point of construction, but from time to time when it's necessary to go on and maintain. The detailed option agreement is an opportunity for the landowner to negotiate detailed bespoke provisions to manage all of that, to establish a long-term relationship. And yes, if they sign up quickly so as to avoid the uncertainty and additional expense involved in having to go through arguments about compulsory acquisition, they get an incentive payment for signing up early. But there's nothing illegitimate about that. It all has a legitimate purpose. But more importantly, it's an overall package of measures that the landowner, with the benefit of advice, has decided is in their interest. And if they choose, against that background, to agree not to exercise their right to object, that's a matter for them.
Can I just ask about the public interest in that point? I entirely understand the commercial aspect of it, but suppose, to take Dr. Jimson's position, he had decided, oh, well, for an extra 5,000, I won't pursue my aquifers argument. Wouldn't that have denied the examining authority relevant information? And you say, consistent with the submission you've just made, fine.
First of all, no, as a matter of fact, on this case. To set the context. But secondly, insofar as on the facts of this case, it happens to be that Dr. Jimson raised a point which was accepted to be relevant and was therefore dealt with. That does not in itself establish that it would have been illegitimate had he chosen not to raise it, because had he chosen not to raise it, that would have been with the benefit of advice and his knowledge about his land. So if he had been satisfied that any issues of that sort that might have arisen could be dealt with within the scope of the terms of the option agreement and how the works would be undertaken, and therefore, for example, mitigation and protection measures to ensure there'd be no damage to aquifers. If he knew that and was satisfied that that interest would be protected, that's a matter for him. In the same way that if he had been satisfied reading the application that that wasn't a problem without further protection, he could have chosen not to raise it.
But that's assuming the aquifer related only to his land. If we go back to my lady's wretched example of the Marsh Harrier, which flies on different bits of the land, that isn't restricted to the land. Would you still say that was lawful?
Absolutely. And the reason why is because if we owned all of that land, the decision maker would be no worse off. The process would be no less lawful. The public interest would be equally well served, because the process and the important provisions which my learned friend has set out at length, which ensure that all relevant information is obtained, and ensures in particular that where there are what are called statutory nature conservation bodies, to take a biological, a biodiversity example, that they are engaged in the process. Questions are put to them, they put in submissions. If, to take the marsh harrier example, there was something, a protected species, a species that needs to be dealt with, one of the ways in which the system seeks to deal with that is ensuring that statutory consultees such as Natural England, within whose remit that species would lie, are properly engaged.
Thank you.
In other words, and it comes back to the point your Lordship raised in discussions yesterday. In principle, if it works with the applicant owning all of the land, it works if some of the land is owned by landowners who choose not to object. The system doesn't rely on landowners objecting. And hence there's no public policy difficulty with these clauses. So, my Lord, against that background, I was going to move on from Fulham. I didn't have any further submissions to add on that. And it was simply then to deal with two final points, which I think I can deal with before one. The first is the public law categorisation issue. And simply say this, the point came up in discussion yesterday with Mr. Bewley as to whether this was a Wednesbury point or not. And Mr. Bewley said it wasn't because it's an issue about fairness. But in this litigation, there's been no allegation of procedural unfairness, even though that was the first complaint. But it was then said, well, the test, if it's not Wednesbury, is whether there's a real risk. So where the possibility arises, a real risk test applies. But no authority has been cited in support of any such test, or indeed to identify any separate principle of public law that might fit the appellant's needs. The appellant is effectively casting around to try and find some principle of law, but identifies none, identifies no authority to support one. It is, I submit, simply another reformulation of the essential argument. Once Sayers had raised the allegation, there was no way the Secretary of State could lawfully grant consent. That's where all roads lead on the appellant's case. My Lord, finally, on the Senior Courts Act, the only point that I wanted to raise here is an additional point about the overall planning context. Mr. Bewley went to the conclusion of the examining authority as to whether the planning balance was fine or not. That was not a conclusion that was reflected in the Secretary of State's decision. The Secretary of State did not say that the matter was finely balanced, but importantly went further than that and dealt with the case on the basis of what's known as erope. That is, it was necessary in that case to consider whether there were imperative reasons of overriding public interest for the development to proceed. So if one goes to page 493 of the bundle,
The core bundle.
the core bundle, I do apologise.
Thank you.
Behind tab 30. So paragraph 1728 through to 1736 deal with the issue of whether a development having an adverse effect on integrity on a European site it can only proceed if the project must be carried out for imperative reasons of overriding public interest, and therefore the Secretary of State has considered whether the proposed development is required for such reasons, and concludes, 1729, that there are such reasons, subject to adequate compensatory measures, and that is then addressed and satisfied. But in looking at why that should be, one needs to look at 1730 onwards, and the reasons that are given related to the essential and urgent public benefit the project would deliver in combating climate change and meeting the government's objectives and legal targets. And set against that, those overriding reasons, imperative reasons of overriding public interest why it should proceed, the appellant can identify no specific information or evidence that was or might have been left out of account, let alone anything that's capable of outweighing that conclusion. That even where one couldn't rule out adverse effect to integrity of the European site, the imperative reasons of overriding public interest method should be implemented. And given that the underlying concern was based on a misconception as to whether the heads of terms are legally binding, which my clients made clear throughout the examination was wrong, and that the affected persons who signed up did so with the benefit of independent legal advice, it is, we say, implausible that the claimant's complaint would have affected the outcome if further inquiries had been made. So we say, for those reasons as well, relief should be refused even if the grounds are otherwise made out. Thank you. Those are my submissions, unless there's anything else I can assist with.
Thank you very much, Mr. Philpott. Well, it's just before 1. Mr. Bewley, you're going to need obviously more than 5 minutes to reply. So should we start that at, well, let's start that at 2 o'clock.
2 o'clock. Thank you.
Thank you very much. 2 o'clock.